Olá, bom dia. Bom dia a todos, a todas e a todes. Eu sou Vitória Damasceno, é um prazer estar aqui com vocês hoje. Estou aqui do lado da professora Anita Allen, que já foi muito bem introduzida pela Joyce, mas eu vou falar um pouquinho mais da biografia dela. Ela é professora de Direito na Universidade da Pensilvânia, é uma das maiores filósofas feministas no campo da privacidade e é uma intelectual do campo. Ela recebeu o prêmio Philip Quinn Prize da American Philosophical Association em 2021 e em 2010 foi nomeada pelo presidente Barack Obama para fazer parte do Comitê Presidencial de Bioética. Levei aqui a minha colinha para não esquecer nenhuma informação importante. Queria te agradecer, professora, por estar aqui com a gente. Acabei não falando de onde vim, eu sou editora na Folha de São Paulo, e eu vou estar mediando com vocês essa conversa. A gente vai ter um primeiro momento em que a professora vai fazer uma exposição para a gente, falar um pouco de onde ela vem, o que ela pesquisa, uns assuntos pertinentes, e depois a gente vai ter uma breve conversa, e em seguida a gente abre para vocês fazerem perguntas. As falas da professora serão em inglês, então vocês podem acompanhar com o pequeno aparelho, que eu não sei o nome, mas que tem um fone e tem tradução simultânea. Mais uma vez, obrigada, professora. Fique à vontade.
Obrigada. Bom dia. I am very, very, very honored to be here. This is my first trip to Brazil. I had a chance over the weekend to visit Rio and had a wonderful time seeing the city. And yesterday I walked 10 kilometers around São Paulo with my husband, and we had a nice time. So thank you very much for this opportunity to be introduced to Brazil. I apologize for not speaking Brazilian Portuguese. I have listened to many, many songs by Milton Nascimento over the last 40 years, but still I can't speak Portuguese, so forgive me. I'll speak English. The question that I want to explore with you today is the question of whether privacy is really a civil right. And the way to hear my question is privacy really a civil right? That's the way you have to understand it, because I want to interrogate this question. And it may seem that someone who's left-wing, progressive, black, would not question whether privacy is a civil right, but I do believe that we all need to understand this discourse and to be open to questioning the discourse. So here I go. I have, over the last 40 years, written many, many articles about privacy, and as the slide shows, I've written many, many books about privacy, and in fact, I wrote the first book about privacy in English in the United States. That's not true. The first philosophical book about privacy in the United States in English. So there you go. So I'm very interested, obviously, in gender and privacy, but also in the social impact of privacy, both in the sense of autonomy, but also in the sense of data protection. Recently, I've begun to look closely at privacy through the lens of race, putting a kind of microscope or a magnifying glass to privacy through the lens of race, to understand better why privacy and race have the difficult relationship that they have. I was inspired to think about this topic by some awful situations which happened in the United States about 2 years ago. You may have heard a man named George Floyd was murdered by police in broad daylight. Police officer put his knee on the neck of the man until he died. And this was photographed by someone on their cell phone, raising issues about the role of technology and police violence. But before that happened, there was a young woman named Breonna Taylor who was in her home one night doing nothing, just with her boyfriend. They were asleep in bed, and the police came to her house because her ex-boyfriend was suspected of being a drug dealer. And the police believed that she might be hiding something in her apartment. So they got a search warrant, and they came to her house, and they burst in, and she and her boyfriend were stunned. Her boyfriend had a gun. He shot at one police officer, and then a police shot her dead. And what this Breonna Taylor story tells us about privacy in the United States is that the home, which is supposed to be the sacred seat of privacy, is not safe if you are Black. It's not safe if you're underprivileged. It's not safe. It's not a safe haven if you're someone whom the police have any kind of reason whatsoever to want to investigate or interrogate. So there is a relationship between privacy and Blackness and race in general. And I want in my current work to explore more deeply this connection between privacy and race, going beyond police violence, but I must tell you that it started for me with police violence. There's a scholar at the University of Colorado in the US named Scott Skinner Thompson, who wrote a book called Privacy at the Margins, which talks about the ways in which LGBT, gay people and Black people commonly live in the margins and have privacy problems that relate to their status as people who are not heterosexual white males in our society. And this quotation on the slide is from Scott. Those who are already in the most precarious social positions are disproportionately vulnerable to privacy violations, while privacy of the privileged is more protected, and this, he says, is not an accident. And why is it not an accident? It's not an accident because the oppression of LGBT people is not an accident, and the oppression of African Americans and other Black people around the world is not an accident. I myself am the great-great-great-granddaughter of African slaves who were brought to the United States. Based on my genetic testing, my ancestors come from what would today be considered Nigeria, and both my parents, by the way. They were, my great-great-great-grandparents were enslaved on a plantation in the state of Georgia in the US. The historical memory, of course, of slavery is growing dimmer and dimmer, but yet it's not dimmed enough. Why? Because after slavery was over in 1865 in the US, there was a concerted effort to continue to keep African people at the bottom of the social hierarchy. So efforts were made in the late 19th century to create a regime of civil rights laws for African Americans that will enable them to have the rights of white people to vote, to go to school, to use public accommodations, and so forth. But our Supreme Court, the US Supreme Court, struck down the civil rights laws that were passed in the aftermath of slavery on the grounds that the federal government had no constitutional authority to regulate behavior of people in the states. And so this idea that the federal government had no power to regulate the states meant that the southern states, which had been the states which had endorsed and practiced slavery, were free to continue to discriminate against African Americans. This went on from the late 19th century all the way into the 20th century and all the way into the 1960s into my childhood. So although I'm the great-great-great-granddaughter of African slaves, I continued in my family and history and in my own experience to continue segregation, apartheid in the United States in the 1950s and 60s. So in 1964, we had passed in the United States something called the Civil Rights Act. Civil Rights Act. And the Civil Rights Act undid the constitutional decision from the late 19th century, and now the states were allowed to, the government was allowed, federal government was allowed to enact laws to protect Black people from the ravages of post-slavery underclass status. So in 1960, schools were integrated, public accommodations, hotels, cinemas, swimming pools were integrated, voting was protected, and access to jobs on an equal opportunity basis was protected. And the law, the Civil Rights Act specifically said that race, color, creed, national origin, and gender could not be used as a basis for discrimination. So we have a Civil Rights Act. The question that I'm asking today, and I'm giving this long history for a reason, the question I'm asking today is privacy a civil right? And so to US ears, if you say, is privacy a civil right, you're asking whether or not there's a connection between the civil rights movement of the 1960s and the data protection movement of today. Is there a connection? Is there a connection? When you're looking at privacy through the lens of race today, there is a connection between the conditions of Black people and privacy. And the slide just shows you some of the things that we're concerned about in the context of race and privacy today. These have to do with simple differential in who can afford privacy. Can you afford the house and the fence and the private car and the Apple phone with encryption, or can you not? And then other things too. Facial recognition. The affordability of privacy-protecting technology, I just mentioned that. The ways in which big data algorithms rely upon unfair assumptions that then perpetuate and stereotype Black people. Surveillance technology and how they're deployed by cities and by the private sector. How mass incarceration means that a huge number of Black men especially never have opportunities for privacy and private choice. These are some of the things which American people in the US are thinking about through the lens of race. And there are now wonderful books, and I encourage you all. I'm going to show you 6 examples, but there are wonderful books now, which if you haven't had a chance to read, I hope you can, and I hope some of these are translated already into Portuguese. But Algorithms of Oppression, Black Software, Dark Matters by Simone Brown, Ruha Benjamin, Race After Technology, The Poverty of Privacy Rights, Kiara Bridges, Automating Inequality, and then Camera Power. So there are many, many books you can read in English if you care about the connection between race and privacy. What I'm talking about today is not dealt with, and none of those books talk about what I'm talking about today. So I'm hoping to bring a new conversation, and the paper that my talk is based on will hopefully be published sometime in the spring of next year. But I did recently publish a paper in the Yale Law Journal Forum called Dismantling the Black Opticon. I was looking for a catchy way to encapsulate the kinds of problems that Black people are experiencing in the United States because of technology, because of digital platforms. And I came up with this concept of the Black Opticon. Okay, so what is the Black Opticon? The Black Opticon is the attentive eye of society that is focused on Black people, resulting in a series of problems that I refer to as the panopticon, the banopticon, and the conopticon. So the panoptic problem that Black people face is the problem of over-surveillance, discriminatory over-surveillance by the police, over-surveillance by the private sector, and this is a huge problem. And the example I give in the paper is one in which after a riot occurred over some police violence, we learned that a company called Geophedia was collaborating with some of our Facebook and some other digital platforms, social media platforms, to identify the location of Black people who were participating in these protests, and those people were arrested. They were arrested not because of their traffic problems or their probation problems, because they were at a protest rally protesting police violence, and technology was used to surveil them and then to arrest them. The banoptic problem, and I borrowed the term banopticon from a European scholar named Didier Bigot, but the banoptic problem is people being discriminatorily excluded from the benefits of society, pushed to the margins of society, banned, that is to say, from the forefront of society. And this would include things like the housing ads on Facebook that would that are only shown to white people or people with privilege and not shown to Black people, so they have no idea that opportunities for housing or for banking, loans and so forth might be available. And then the final problem that I emphasize as being pervasive for Black people is the conoptic problem. This is a problem, it's like the opposite of the panopticon. The conopticon is being targeted for predation, targeted for scams, for con jobs online. And in the United States, Black people, Hispanic people especially, have been targeted for online scams that result in the loss of money and opportunity. So these 3 problems together, I refer to as the Black Opticon, and my hope is that this simple framework can be used to help to critique new law. Because if new law that purports to protect data does not grapple with the banopticon, the panopticon, and the conopticon, then they're not good laws. So it's just a framework for critique, asking the question: will the new law do anything to address the Black Opticon. So if there's going to be a new civil rights discourse, if there's we're going to keep talking about civil rights and privacy, I'm asking the question, can any legislation that occurs because of this new civil rights movement in privacy, can it address the panopticon, the panopticon, the conopticon, the Black Opticon? Can it? And if so, how? So this is my project, right? Okay, this is my project, and for about 7 years, I stopped being a professor at Penn, and instead I was working at my university as the vice provost for faculty. And when I finished that administrative responsibility and came back to the law school, I discovered that, oh my gosh, in my absence, something new has happened. There's now this big conversation about privacy as a civil rights. And there was an open letter last year. 57 different civil rights organizations, civil liberties organizations, wrote to Congress saying you must pass laws because privacy is a civil right. And again, I'm thinking, well, okay, what is the connection between privacy as a civil right movement and the civil rights movement of the 1950s and 60s, which led to some important civil rights legislation? So I'm trying to historicize a little bit and clarify the claim that privacy is a civil right. Now, so for those of you who might be, some of you are undergraduates, you haven't yet studied the law, you haven't studied rights discourse and political theory, I think it's important that you understand that the term civil right, human right, and natural right, these terms are not interchangeable. They actually refer to different things. They're all citrus fruits, like this slide. They're all lemons, grapefruit, oranges, limes, but they're different kinds of citrus fruits. And so I want just to take a minute to say something about how these concepts are different, because it's important to understand that even if privacy is recognized as a human right or a natural right, it might not be recognized as a civil right. So civil rights are the rights we have by virtue of citizenship, by virtue of the government, some government, conferring certain entitlements on people, such as the right to be protected from inequality in employment and housing and public services. Civil rights are positive rights. They're rights that are put in place by some sovereign authority. And there's generally some national or some state level or local level capacity to enforce privacy or other civil rights. So looking for citizenship, looking for positive law, looking for some sort of national or sub-national level of enforcement. That's what a civil right is. Human rights, by contrast, are universal. They may be positive or they may simply be declared, and there may be some international monitoring or enforcement. So I think when most people think about privacy as a human right, they think about the provisions of the UN Declaration of Human Rights from 1948, which has provisions that provide that privacy is an important human right. Some later UN documents and covenants also mention privacy as an important human right. But these are rights which are aspirational, but they are declared, and they're positive in the sense that some states embrace these concepts, and there may be some way to enforce or at least to monitor what are considered human rights. And finally, natural rights. I'm a philosopher by training. I got my PhD in philosophy before I became a lawyer, so my identity is very much as a philosopher in most respects. And so I believe I'm a scholar also of natural rights, and I believe it's important to talk about natural rights. What are they? Well, by contrast to the other two, these are inherent and inalienable. They're universal, like national rights. They're foundational. They're the basis of human rights and civil rights, and they have a sort of a historical influence. They come from political theory. They come from mostly from European traditions, British and French traditions. So those are natural rights. And natural rights are sort of philosophical rights in the sense that they're just intellectual constructs that those of us who believe in ethics and believe in moral values also say we believe that there are these sort of natural rights. Okay, now this slide is funky, I know. I was trying to find a way to graphically display the way in which human rights and civil rights relate to one another. So imagine an ocean. Imagine an ocean, right? And there's a boat on the ocean. And the boat represents law, positive law, just law, right? Well, there's a a saying that I like to quote, that in civilized societies, law floats on a sea of ethics. And so for me, the boat of law is floating, it's held up by ethics. And the layers of ethics for me would be civil rights, and then below that, human rights, and then below that, natural rights, which are foundational and fundamental. And these are ethical values. So holding up the law, if it's legitimate at all, are these rights, civil rights that are enacted by our societies and hopefully enforced, and then by human rights, and fundamentally by ethical values or natural rights. That's just how I see the connection between these three. So when I ask the question, is privacy a civil right? Really, what I'm asking is there some foundation for our law that is aspirational, that needs to be recognized in our law? And I think in the United States right now, when we say privacy is a civil right, we're saying that we aspirationally, we wish privacy were a civil right. We hope privacy will be a civil right someday, because it certainly isn't right now. It is not a civil right right now in the United States. Now, one might contrast this with Brazil. Again, I am no expert on Brazil. I have to be corrected, okay, but this is my impression. So the English translation of a law that was enacted in Brazil in 2014 is civil rights. It had civil rights law protecting the internet. We don't have anything in the United States called a civil rights law protecting the internet, right? Use of the internet. We have nothing like that. We also don't have anything like your LGPD. We don't have an LGPD based after the GDPR. We don't have that in the United States. We've been trying to get it. We have a couple of states, California, Virginia, which have passed state-level laws that are loosely modeled after the GDPR, but we don't have it. We don't have a civil rights discourse in positive law yet in the US. We don't have a GDPR influenced national law. We have nothing. We have nothing. Okay, we have nothing. So again, if we say, oh, privacy is a civil right in the US, all we're saying is we hope someday Congress will pass a statute. Now last year, Congress got very close to passing a statute, because all these organizations on this, we want this. All these centers for civil rights and scholars like Danielle Citron are arguing for privacy as a civil right. But no matter what the scholars say, no matter what the centers and different organizations say, we don't yet have privacy as a civil right. And so I'm wondering about this connection in Brazil between civil rights and minority harm, because it seems to me that when you pass that law in 2014 and when you pass that other law in 2020, you didn't have minority rights in mind. My impression is that even when the language of civil rights is used, and even though the Brazil law of 2020 has lovely language about respect for privacy and freedom of expression, inviolability of intimacy, honor and images, economic and technological development and innovation, free enterprise, free competition, human rights, free development of personality, dignity, exercise of citizenship by natural persons. Despite all that language, that there was not a I'm just, tell me if I'm wrong, there was not a focus on using that language to protect minorities who might be discriminated against, including your own black population and your indigenous population. Because I'm reading that Brazil has some of the same problems we have in the United States. Problems with facial recognition, for example. I read an article, and this is just a quotation, facial recognition surveillance in São Paulo could worsen racism. I read about a program called Stampa. Yes, an effort to have a sort of a camera-based surveillance scheme throughout the city to make things better, right, safer, and yet there's concerns that this could also have a disparate impact on black people, especially black men, young black men, and there's a concern about that as well. So it seems to me that while the United States, I am in awe of how much legislation you have had to focus on problems of the internet and problems of data protection in general. But I fear that just as in the United States, we have a problem of the law not reaching out broadly enough to protect minorities. You have a similar issue in Brazil, and I'd love to hear more about that today. Tell me if I'm wrong. I understand you have a connectivity gap in Brazil, where there are a lot of people who don't have access to the internet. A lot of indigenous populations and people who are the descendants of slaves have issues with technology, accessing technology. I confess that if the U.S. is supposed to be some kind of first world model, we're not. We're not. That we have dismal benchmark, quoting dismal benchmark for the right to privacy online. Okay. So although I think in terms of positive law, Brazil and the U.S. are very different in terms of having issues for LGBT, for Black, for Indigenous, et cetera. And women, there still are problems in both societies. And I just wanted to restate what I stated earlier, which is that the early uses of civil rights discourse in the United States were directly tied to what you see on the slide, which is discrimination against Black people, white people not wanting to associate with Black people in any capacity other than as servants and former slaves. So now, it's interesting to think about the history of data protection and privacy in the U.S. context. There was a time back in like 1904, 1905, when a white woman, the woman you see on the slide, she sued a company that made flour for baking, because they used her photograph on the packaging without her permission, calling her the flower of the family. It was a pun. And her case failed because there was no such thing in 1904 to a right to privacy, so her case failed. But the New York legislature was horrified that a young white woman could be commodified and have her picture put on flour without permission, that they passed a law that said that you could no longer use someone's photograph or any other attribute of their identity for commercial purposes without their permission. And this law was packaged as a civil rights law, New York Civil Rights Law 5051, along with other just laws of citizens. But this did not mean that there was a general civil right to privacy in the United States. It meant that New York chose to categorize this new right against commercial appropriation in its civil rights legal book, you might say. What's more striking to me from the same period is a case from the state that my parents come from, Georgia, a case involving a white man, who also was unhappy because his picture was used without his permission for advertising. This gentleman's name was Pablo Pavsic, and he woke up one morning and found that his photograph was being used in an ad for insurance, life insurance, in a newspaper. And the ad suggests that he'd purchased life insurance from a New England life insurance company and therefore was having a jolly life. But it was completely untrue. So he sued for invasion of privacy. Unlike the New York court a couple of years before, which said there's no such thing as a right to privacy, this court, this judge, Judge Andrew Jackson Cobb was his name, this judge said, there is a natural right to privacy. There could be no civilized society without recognizing a right to privacy. And so I'm going to hold that there is a right to privacy in Georgia and that it can protect someone like Pablo Pavsic. So we got a state law right to privacy in the U.S. for the first time in 1906, in this case called Pavsic versus New England Life Insurance Company. And why do I have a picture of an enslaved man and his scars on the slide about this case? It's because in the what we call the dicta, in the opinion written by the judge, he analogized invasions of privacy, like having your picture used without your permission, to slavery. He said that when you use someone's image without their permission, when you drag someone out of their homes and turn them into a public thing, you are to that extent using them, and to that extent they are under your control, and to that extent, they are no longer free, but they are in reality a slave without hope of freedom, held to the service of a merciless master. When our privacy is invaded, we're like slaves held to the service of merciless masters. And now, this, for many years, I read this language, and it was just always just a metaphor. It's a hyperbolic speech. But I began to focus on who said this. And so Andrew Jackson Cobb, the judge who wrote this opinion, was himself the son of a man who owned slaves. His father owned slaves, his grandfather owned slaves, his uncles owned slaves. In fact, one of his uncles wrote the constitution of the breakaway republic, the Confederacy, that started the Civil War. So he was very familiar with slavery. He'd been cared for as a child by enslaved black people. So I don't think for him he was just using this as a metaphor. I think he really meant that there's something like slavery involved in invasions of privacy. Invasions of privacy attack our freedom in a very fundamental and important way. So for me, this case, this language, this image is a very important reminder of the connection between privacy and even data protection and race. Because the problem of slavery and the problem of race are intertwined in the Americas, not just my country, but also in your own, which freed the slaves after my country did. So does the history of civil rights as a discourse support the current characterization of privacy as a civil right? And I just wanted to throw out a couple of things for your thought. One is that this woman, Dalry Mapp, in the picture, was a black woman who was arrested after the police came to her home and they found some pornography in her home, and they arrested her for this and charged her, and she was criminally convicted. But she protested. She appealed to the Supreme Court because she believed her privacy was violated because they had come to her house without a proper search warrant, and she won. And her case established what we call the exclusionary rule, that the police, that in a criminal case, you cannot use evidence that was collected without a proper search warrant. So her case is this black woman created, by her bravery of bringing this case forward, she created the exclusionary rule that helps everybody, black and white, who are faced with criminal prosecution based on evidence that was obtained without a proper search warrant. In the middle of the slide, we see a picture of a family. This is a case, this family is the Loving family. The Mrs. Loving in the picture with a white blouse. Mrs. Loving was married to a white man. She was herself Native American, indigenous, and black combination, mixed race person. She brought a case to the Supreme Court because her marriage was declared not just invalid, but criminal in the state of Virginia, where she lived. And by the way, Virginia is the state adjacent to the Washington, D.C., so that's where it is geographically. So she brought this case, Loving versus Virginia. She was suing her state because her state had criminalized her marriage and told her and her husband, leave the state or go to jail. Those are your choices. Leave the state or go to jail. She brought a Supreme Court case. She won the case establishing the right of interracial marriage. This was 1967. I was a teenager when this case was decided, so it's not so long ago in my mind. And then finally, an older case, NAACP versus Alabama. Again, black people in the vanguard. Black people promoted the idea that there should be associational privacy. The case involved an effort by the state of Alabama to require a civil rights organization to give them their membership list. The NAACP, the civil rights organization, did not want to give Alabama the membership list because then it would enable Alabama to harass the people who belong to the organization, maybe even to burn down their houses, burn down their churches, or kill them by lynching, which was happening in Alabama at the time this case was decided, 1958. So our Supreme Court said, yes, there is a right of associational privacy. No, the state may not require an organization to give up their membership list to the state. So my point here is that African Americans have been in the avant-garde of pushing for privacy rights in the United States. Associational privacy, privacy of the home, privacy of the family, and yet it seems as though privacy rights in the data protection area are not being as focused as they could be on the problems of black people and other marginalized communities. And now my clicker's not working. Help with clicker. Let's see, go backwards. Clicker's not working. Text help, suck help. Yeah, okay. But I'm going to keep talking. Oh, there we go. Okay. Okay, so it's working up there, but not down here. Oh, okay, great. That's fine. Okay, so, all right. So now the question I want to just throw out here is whether the right to privacy has actually stood in the way of civil rights. So far from privacy being a civil right, is it possible that privacy impedes civil rights. And so I want to talk about Hannah Arendt, who was a European philosopher who came to the United States during World War II to escape the Nazis, and she became a famous professor, wrote many important books, and in one of her articles, she wrote about the civil rights movement and about whether or not the federal government should have been compelling public schools in the South to integrate, to allow for education of black children side by side with white children. And Hannah Arendt, who used to be one of my heroines until I read this article she wrote, she argued that it was an invasion of privacy. It was an invasion of privacy for the federal government to compel publicly financed schools to admit black children. Right? Education is a private matter, she argued. If the white parents want to keep their children away from black children, they should have a right to do that. The school is an extension of the family. So what if the school is paid for by tax dollars that include the taxes of black people? There should be a right to educate in segregated contexts. So the right to privacy could be oppositional to civil rights and equality, equal treatment. And so as we think about whether privacy is a civil right, we have to remember that there's this intellectual possibility that in the minds of some people, privacy may actually be an impediment or be a barrier to some civil rights aspirations. So the question I now want to ask is whether or not people of color will benefit from laws that are designed to protect civil rights. And I have grounds for skepticism. I've already said to you that I'm concerned, and it's a question because I'm not familiar with your law, a question whether or not your own privacy data protection laws are effectively protecting the rights of minority folks. And I just want to tell you why in the context of the United States, I have grave doubts that our privacy laws that are being discussed would actually do much to promote civil rights. So why the skepticism? So in the article that I wrote, I mentioned earlier, the article Dismantling the Black Opticon, I look in detail at the Virginia statute that was enacted last year, 2 years ago now, to protect data protection. It was a data protection statute to protect data privacy, and then a proposed national law that was on the table at the time, the article, that had some interesting features to it that I thought were pretty positive. I'm just share with you then sort of three categories of possibility and how these laws matched up to those possibilities. So one possibility is that you can have a privacy law that is neutral on its face. And so in theory, the privacy law, data protection law, would protect everybody, regardless of race, color, creed, national origin, disability status, veteran status, et cetera. Everybody would be protected, right? Gender, everybody. And I think that there's a sense by many important civil rights groups in the United States and many advocates and many scholars that that's not enough. What we need is a statute or a law that specifically has anti-discrimination provisions in it. And so what you see in a number of the pending and actualized state laws in the United States, you see some language that says that thou shalt not discriminate based on race, et cetera. So an anti-discrimination provision is included in the law. Sometimes the law refers the reader of the law to another statute which protects civil rights, so it's there by inference, but sometimes the law has its own civil rights statute. And I love the fact that in the proposed federal statute that was discussed in my paper, that the statute actually provided that the federal government would create an agency, a data protection agency or authority. You have one in Brazil. We have none in the United States. This statute would have created an authority, and that authority would have had included a civil rights division that was there to focus on civil rights and their enforcement as a matter of data protection. Well, that statute was never passed. It was a lovely thought for years, but it was gone. It's gone. It's not there anymore. But that kind of thing, I think, would be better than just a facially neutral statute, which didn't mention civil rights at all, didn't have an anti-discrimination provision at all. But what I fear we might need is something more than even that. and the thing we might need that I'm pushing for is that we have a law that specifically addresses the Black opticon and the gay opticon, or the queer opticon, as one of my students puts it, the queer opticon, that directly embraces the kinds of problems that marginalized communities are experiencing and makes those kinds of things unlawful, or addresses those kinds of problems to make things better for these people who live in marginalized communities. So what do I have in mind? I have in mind, for example, a statute which explicitly recognizes, for example, that facial recognition technology is flawed and should not be used unless it's been tested and shown to be accurate enough to not result in people with dark skin being put in jail unlawfully. Right? So you need to have laws that specifically recognize the kinds of problems that people of color are experiencing, and does something to fix that, to require more accountability, to have prohibitions, to have more transparency, et cetera, specifically related to the problems that people of color and other marginalized communities are experiencing. That kind of law, I think, is the true aspiration, not just a law that says thou shalt not discriminate, but actually naming the problem and trying to fix the problem. Naming the problem and trying to fix the problem. I know you've had this issue here in Brazil, but we've had it in the US as well, where in one case in the US, a Black man was arrested and jailed for a robbery. It turned out some other Black man had gone into a hotel gift shop, stolen a candy bar, and then tried to escape in a car. And somehow a photograph of this gentleman who did the robbery was taken, probably the camera in the hotel, and the police used this picture from the hotel camera and they went to a database, and they tried to match that picture to see if somebody in the system would come up. And they matched the picture of the guy in the store with a man who didn't live in the same city, didn't own a car or have a driver's license, so it couldn't have been him. Yet it took days for him to be released from jail after the mistake occurred. And this happens all too frequently. People ripped out of their family home. Oh, come, you're being arrested. Why? Because you did something. No, I didn't do it. Well, the facial recognition didn't properly work. I have a relative who used to work for Microsoft, and who told me that during the development of the Wii, it was a game console, they had a terrible problem with the technology not being able to recognize the position of people who were Black. And there are many examples of this going around, and this is just sort of one of them. All right, so that's what I'm asking for. I'm asking for laws that specifically address. But now, okay, so let's suppose that we have a lovely world in which data protection is being protected by state and federal laws that name the problems suffered by people of color and other minorities, and they seek to address those problems. So now we have a lovely data protection regime that's just responsive. We still have a problem of privacy and society, privacy and justice. So what's happening today that I'm finding very troubling is that there's a lot of advocacy of privacy in the data protection realm, but what about other forms of privacy? What about abortion privacy, for example? What's happening there? So ironically, as the discourse of data protection privacy as a civil right is rising in the United States, the discourse of abortion privacy, reproductive rights, is declining, it's falling. So one discourse is proliferating, the other is sinking to intolerable levels. So as you may know, we used to have in the United States what I would call a model of privacy regime, where women could could use birth control, obtain birth control, and they could obtain abortions without having to justify their decision to anybody. It was truly a realm of privacy. Medically safe abortions, medically safe birth control was widely available, no questions asked. By contrast, in other countries, including European countries, women had to present reasons for their abortion to the state. In other jurisdictions, abortion was completely prohibited. And then in one jurisdiction, no longer the case that China is like this, but it used to be that under the one-child policy, China is a country where women were feeling compelled to have abortions to avoid breaking the law. So this used to be the model of privacy and permission, prohibition, and prescription, the global privacy protection model. models. But now what's happened is that there is a liberalization of abortion rights, if you look at it sort of globally. But the United States is not liberalizing its reproductive privacy laws. Instead, the United States is shrinking protection for abortion access. And so, as the slide suggests, this is a quotation from the Guttmacher Institute. No, sorry, this is a quotation from the Center for Reproductive Rights. I sometimes quote the Guttmacher Institute, but this comes from the Center for Reproductive Rights. Over the last 30 years, more than 60 countries have liberalized their abortion laws, but the United States, Poland, Nicaragua, and El Salvador have not liberalized their abortion laws, and we have gone backwards recently. By the way, Mexico, as you know, decriminalized abortion in September of this year. Bravo, Mexico. But our Supreme Court last year overruled our constitutional decision protecting abortion rights in a case called Dobbs versus Women's Health Organization. And in this case, the Supreme Court said, wrong, there's no federal abortion right. Our Constitution does not protect women's access to abortion. It's ridiculous to think the American Constitution protects abortion. Roe versus Wade was wrong when it was decided. It's wrong now. No abortion rights. That's the end of the story. Now, women have abortion rights only if their particular state chooses to give them abortion rights. Okay? This is a map of the United States. The brown areas are states that have pretty much criminalized abortion, and it's difficult or impossible to get an abortion in these brown states. The states in yellow are states that are protected, and blue actually represents expanded access, like California, New York, very, very liberal. My own state is one of the ones that are sort of in question. I live in Pennsylvania. So abortion rights are losing ground. There's legal disarray. Suppose you're a young woman, and your home state is, say, New York, but you go to university in Texas, and you have a summer job in Nevada, which is a completely realistic scenario. Well, you get pregnant. You think, can I get an abortion? Because the law is different in every single state, it's a very difficult question to answer. I mean, so it used to be the case that you could expect to be able to obtain a medically safe abortion wherever you are, but now that's no longer the case. And the idea of privacy was the chief concept used legally and also ethically in the U.S. to defend the right to abortion. But that discourse of abortion privacy has almost disappeared. And even though we're talking about privacy in connection with data, why data privacy? Why not my own body? Why isn't my body privacy? If my data's privacy, why isn't my own body private as well? So, for me, abortion access is vital. It's vital to recognizing women as citizens and persons, moral agents, parents. It's also vital for health and for life. In the United States, Black women are disproportionately experiencing death from pregnancy, infant mortality from pregnancy. Black women want to avoid these kinds of problems by having abortions if they're not in a position to want to have a child or take those risks, but yet they can't obtain those abortions because now they are illegal in many of the states in which Black people tend to live. So it's a very difficult problem. And if you value fairness and equity, and you value women's health, and you value infant health and safety, then you really can't be happy with the trend that's happening in the United States. So there we go. So going back to the question that I began with, is privacy a civil right? Is it really a civil right? I think that from the point of view of ideals, ethical ideals, foundational ideals, privacy should be a civil right. And by privacy, I don't just mean data privacy. And data privacy is very important. That's why we're here today, right? Global data privacy. But it's not the only privacy issue that's important. And I think that to some extent, that the emphasis we've been placing on data protection has not allowed, but it's been not allowed and not at the expense of bodily autonomy, but I wish, maybe I should wish, just as I wish for more protection in civil law context for data protection, I also wish for more privacy as autonomy. There we go, Victoria.
Muito obrigada, professora. Acho que deu bastante coisa para a gente pensar e para a gente discutir agora. Alguns conceitos que já são discutidos, outros que são menos por aqui. A gente vai ter agora alguns minutinhos que eu vou fazer algumas perguntas para a professora, e em seguida a gente abre para vocês. Tem um microfone aí embaixo? É isso? Beleza. Aí vocês podem fazer a pergunta diretamente. E, professora, eu queria começar me questionando um pouco uma coisa que você trouxe aqui, mas também discute muito no seu artigo sobre o Black Opticon. A senhora diz que, se a gente não tem um reconhecimento dessa distribuição desigual da privacidade, muito do que você falou aqui, e quando a gente fala das leis sobre privacidade, né, que tem essa fachada neutra, que a senhora disse que não é o ideal, né, que a gente precisa de leis que enderecem questões de populações minorizadas, como a população negra. Que é improvável que alguém sem esse reconhecimento consiga, como que eu posso dizer, escapar desse Black Opticon, desse tripé que a senhora falou aqui. Mas eu fiquei refletindo sobre isso, refletindo também agora de tudo que você falou, e me parece um pouco inescapável, de forma geral, mesmo para a gente que conhece questões raciais, conhece questões de gênero e também conhece questões de privacidade de dados. Por exemplo, sendo uma mulher negra, me parece, às vezes, simplesmente inescapável. Existe alguma situação, alguma forma em que a gente consegue escapar desse Black Opticon que a senhora fala?
Thank you. Ideally, I would like to say, oh, yes, we can escape the Black Opticon, but I'm hesitant to say that. First of all, over-surveillance. If you think about it, Black people have experienced over-surveillance from the time of slavery, right? I mean, back in the days of slavery, Black people needed permission to pass from one state to another, one farm to another, one plantation to another. They were constantly under surveillance of their owners and agents of the state. And then once Black people were no longer slaves, they were still segregated into communities that were placed under police scrutiny. Many Black men are incarcerated. Mass incarceration puts people under surveillance. So I don't think it's going to be easy to escape the over-surveillance dimension of the Black Opticon, although I think we could make it marginally better if we address things like the tendency to want to put cameras everywhere. Police officers wear cameras. Cameras are on the streets. People are digitally surveilled as they negotiate the internet and so forth. So some of that could be made better, but I don't want to overpromise or overpredict that we're going to have an end to the problem of over-surveillance. The problem of discriminatory exclusion, I think, too, we can make it better. If Facebook made it better by taking those targeted ads off of their platform, but the problem of Black people being pushed to the margins of society and left out while others get opportunities, that's a problem which I think is going to be there for a while. Discrimination based on race, on color, as you might see here in Brazil, are perennial problems that don't have an easy solution. But I think we can marginally make them better, both online and offline. And then finally, the problem of discriminatory predation. I think you can make things marginally better. The example that I give in my paper is of our Federal Trade Commission going after a company that was targeting vulnerable Black people with advertising for these sites that do background checks on people. Black people were being made to believe that they might have an adverse criminal history, so they were spending money to find out if they had criminal activity, and they didn't have any, but the company was making them afraid they might have some. So that practice was eliminated. So you can do some things to deal with attacks on people that are intended to sort of lure them into con jobs. But to make it go away entirely, I don't want to say that's going to happen through the kind of laws we would pass in the data protection framing of things.
Certo. E você falou antes, falou agora, e a gente tem uma discussão muito grande no Brasil sobre essa questão do reconhecimento facial. A gente tem hoje secretarias de segurança pelo Brasil inteiro que estão adotando essa tecnologia como uma forma de segurança pública. A gente tem empresas privadas também que adotam essa tecnologia em espaços públicos, muitas vezes por meio de parcerias públicos-privadas, de concessões. E, ao mesmo tempo, a gente tem a discussão, que é justamente essa discussão que a senhora traz aqui, de que a tecnologia de reconhecimento facial ela tem um viés racial, né, que é um viés que vem da sua raiz. E essa é uma das muitas formas em que a gente observa que a privacidade de dados das pessoas negras acaba ficando um pouco deixada de lado, digamos assim. Né? Por exemplo, essa é uma tecnologia que existem diversos estudos e artigos que falam que ela larga as portas da prisão para a população negra, mas, ainda assim, a gente tem ela sendo implementada em diversos estados. O último levantamento que a gente fez na Folha, por exemplo, falava que 20 estados brasileiros já tinham essa tecnologia. E aí, quando a gente fala, pensa nessas coisas, privacidade de dados, população negra, a gente tem uma questão no Brasil com relação também ao encarceramento, que é muito forte. A senhora acredita que é possível que a gente crie uma normativa legal que nos ajude a superar isso? Eu acho que superar, pelo que a senhora já nos disse, talvez a gente não consiga, mas, de alguma forma, a gente, de fato, tenha um avanço nesse sentido. E eu me questiono isso porque parece algo que já está tão enraizado na nossa cultura. Tanto o Brasil como os Estados Unidos são países que são escravocratas, né, escravizaram milhões de negros, né, ao menos aqui no Brasil. Então, me questiono se é otimista demais pensar que, em algum momento, a gente vai ter uma normativa legal que vai garantir esse direito à privacidade.
Yeah, we do have a problem with facial recognition not being accurate enough to prevent these horrible human rights violations against Black people when the technology has not been properly trained. But one day it's going to be perfect, right? The technology will get better and better and better. Then what's going to be our argument, right? Is it that nobody should be subject to facial recognition technology? I think the problem may be with the idea of facial recognition technology itself sort of catapulting us into a science fiction world in which everywhere we go, everybody knows who we are and all about us. And so the problem is beyond the problem, I think, just of Black people, because I think the technology will get better. And by contrast, some of you may know that in India, another large democracy in the world, the country decided to adopt a national ID card based on biometric identification. It uses iris scans and fingerprints along with demographic information encoded to create a code that then everyone has to show this card to access public services. And I wrote a little bit about this card because when the Indian Supreme Court heard the case against the using of it's called the Aadhaar card, they actually cited some of my scholarship in the Supreme Court decision to support the idea that privacy is a fundamental foundational right, and therefore that if you're going to have a national ID card based on these potentially privacy invading technologies, there must be some privacy protections built into the system, right? So I guess what I don't want to obsess about facial recognition, because I think it's going to get better. It's horrible right now. It's going to get better. Even when it gets better, there's still going to be biometric identifiers that can and will be used around the world. And I guess the bigger question is do we want a world which may seem safer and more secure because of technology, or do we want a world in which people have the ability to be more anonymous as they transact everyday life? This is a philosophical choice that I think societies have to face and have to address.
Ok. E quando a gente pensa nessas questões, nesses problemas de segurança de dados, agora também inteligência artificial e questões raciais, a gente falou agora do reconhecimento facial, fico feliz que você pense que que vai melhorar, que a gente vai atingir um nível positivo, digamos assim, dessa tecnologia. Você consegue pensar hoje num principal problema quando a gente faz esse cruzamento de privacidade de dados, questões raciais, de gênero também? Não sei se talvez questões raciais, questões de gêneros tenham ali problemas diferentes.
Yes. Thank you for that question. Artificial intelligence. Okay, so I think that the biggest problem I'm having with AI in connection with race and data protection is the idea of prediction being deployed in contexts where there may be a noble-sounding reason, like crime control, right, that justifies using predictive AI to identify where crime is most likely to occur, because the focus on certain neighborhoods as high crime neighborhoods and putting police in large numbers in those neighborhoods, that potentially makes things worse. Because as you know, wherever the police go, they will see crime. If they go to the rich neighborhood, they can see crime. But if they're using predictive models which say go to the black neighborhood or go to the favela, then that's where they're going to find the crime, and those people will be more subject to arrest and police abuse than other people. So I think that there's a large problem with these predictive technologies. Also, that's one kind of, but AI that points people to that involves political manipulation, right? For example, when we saw that in the elections in the U.S. a couple of years ago, political manipulation can be used. AI can be used to affect political manipulation. AI can be used to target advertising. AI can be used to as I said, to instruct police as to how to make things better by where to focus their attention. But AI is a beautiful thing when used properly. President Obama, a big hero of mine, when he was the president, his administration issued a big report saying we should use AI for good. AI can help improve access to public services, can make public agencies better, right? So we don't want to say AI is an evil thing flat out. But we have to be careful that we don't use AI to justify repeating past stereotypes, biases, social inequities. We don't use AI simply to repeat the past. We want to use AI to make things better for the people, all of us, but especially for the people who've been disproportionately harmed by our legal and societal practices.
E pensando, fiquei aqui divagando enquanto a senhora falava, e também um pouco na questão da privacidade de dados versus, digamos assim, uma privacidade geral. E a impressão que eu fiquei um pouco é que, quando a gente fala, por exemplo, de população negra, a gente está tão atrasado em dar privacidade adequada que parece que a privacidade de dados é um assunto além dos problemas que a gente tem hoje. Não sei se a minha impressão está certa, porque é isso. A gente tem uma questão que você falou dos mandatos de que entraram na casa de pessoas sem mandato de busca, e a gente tem isso no Brasil, à torto e à direita, o tempo todo, e isso é uma questão de privacidade. Às vezes eu penso, a gente está tão atrasado nas conversas sobre privacidades, quando a gente fala sobre população negra, que parece que privacidade de dados é um passo a mais. Queria que você comentasse um pouco sobre isso, pensando nessa questão desses universos da privacidade.
So your question gives me an opportunity to make a comment that I didn't make during my main remarks that I very much wanted to make about the politics of privacy discourse, all right? Because privacy discourse has a politics to it. And I think that many people of color are absolutely correct in not thinking that data protection or other forms of privacy are all that important to them, because they think that the problem of, say, police violence, mass incarceration, poverty are much more important and salient problems. And privacy seems like it's focusing on something that's upper middle class or not really, a part of the lives of ordinary people. What I would hope we can do is to help communities better understand the connection between poverty and over incarceration and privacy. I showed a slide earlier in my talk of several different books written about race and privacy. What I should have said is that some of those books don't mention the word privacy. They're books about race and technology, but not books about race and privacy in technology, because privacy itself is not seen as the main concern. But I think it is a concern for people of all different backgrounds. Part of the politics of privacy discourse that I'm seeing in the U.S. is that, first of all, in the abortion and reproductive rights and gay rights context, we're seeing the many intellectuals on the right wing and many courts that are right-leaning. They're saying, oh, privacy discourse is not grounded in any constitutional provision or has no constitutional status, and it's vague, and it's unclear what we even mean by privacy. So the very concept of privacy and the law is demeaned. And then, so that's on the right. On the left, you see people progressively trying to push for civil rights, that privacy is a civil right, and push for more privacy rights, more privacy for women and gay people, et cetera, and the poor. But yet, the two sides have a fundamental disagreement about whether privacy is too vague for the law or privacy is exactly the concept we ought to be using for the law. And it's important to understand that the choice you make between privacy is hopelessly vague and privacy is a concept we can use powerfully for the law, it's a political choice. Because if you side with the side that says privacy is vague, you're feeding into, you're fueling non-progressive social institutions and practices. If you say privacy is a concept we can deploy for civil rights and for advancing human rights and so forth, then you're on the side that will hopefully push for more protections for marginalized communities. So there's this right-left split in the way privacy discourse is understood, and I think that politics needs to be present. You can't just say, oh, philosophically, I think that privacy is bullshit, and because if you say that, you're fueling, I think, the right wing, even if you're left wing or far left. So privacy is a political discourse. I have in another piece that I've written that I didn't share with you, Victoria, because it hasn't come out yet, but it's a piece that's going to be in a handbook of applied philosophy of language about the privacy discourse. And one of the things I do in this paper is I talk about the need to stop trying to abstractly define privacy and then criticize marginalized communities because they don't understand privacy. Instead of prescriptive definitional analysis, we should engage in what I called critical facilitation, where you listen to what people are saying in the community, in the favelas, in the poor neighborhoods. You listen to what people are saying, and you decide whether they're making a just claim, and then you facilitate their pursuing their just claim, regardless of whether they're using concepts like privacy in some suboptimal way from the point of view of Oxford philosophers, right? So it shouldn't be about what, ideally, philosophically, we think we can defend using theories of philosophy of language, blah, blah, blah. It's about what are the material problems on the ground. What discourses are people choosing to use to fight for an improvement of those material conditions? And if we agree with the material problem being a problem, let's address that. Let's forget about trying to find the ideal definition of privacy.
Ok, muito obrigada, professora. Queria abrir para as perguntas. Já temos algumas pessoas. Vou ali atrás, você nessa segunda fileira, que foi muito rápido levantando a mão.
Okay. Hello, Professor. Thank you very much for this wonderful presentation. My name is Joaquin. I'm a law student here in ESPM. And through your presentation, when you were going through the examples, right, of the history of data protection, of the history of the discourse around civil rights and privacy, and how Black people are on the front line of this discourse from a long time ago. most of your examples were focusing on protection of minorities against the government in the terms of privacy.
Yes.
Except for one example that I noticed, the example of the ad, the Facebook ad, right?
Yes.
And when you mentioned the discourse in Brazil and how you actually said, correct me if I'm wrong, but I actually think you made a very precise analysis of the Brazilian discourse around the privacy legislation, that it doesn't really have a focus on minorities. The LGBT is very much focused on protection of privacy and privacy data against companies, right? It's not as focused on protection against the government. I'd like to know if you think that the focus on protection against the government is a more primary problem to address than the protection against companies when you're thinking it through the lens of race or through the lens of gender and other types of minorities and other types of groups that can be oppressed. Thank you.
Thank you, and congratulations on being a law student. I think that the problem with the private sector is very important. So I mentioned earlier that I looked very carefully at the Virginia state statute in the US, and it was a consumer privacy statute aimed at the private sector. The private sector loved the law. The big data platforms came out saying, great job, Virginia. But from the point of view of those of us who care about minority rights, the statute was pretty flabby, actually. It did almost nothing to address the black opticon. And one of the weaknesses in the law was that it did not provide for a private right of action, meaning that if you were a citizen and you believed that some platform or some a private company had violated your consumer privacy data protection rights, you wouldn't have the ability to sue. You'd have to hope that your state attorney general sued on your behalf. Now, if I lived in New York or California, I wouldn't be so concerned about whether the Attorney General would listen to me as a black woman of color, right? Woman of color. But if I lived in Virginia, which is a former member of the Confederacy, slave state, I would worry a lot about whether or not the politics of Virginia would allow the Attorney General of Virginia to represent me aggressively in a battle against Google or Amazon or Microsoft or any other, Uber or any platform for that matter. So I think I don't think that the private sector problems are less important, even though I stress them less today. But I think instead that they may be more difficult to address because of the role that the market economy has in the American consciousness and the unwillingness of some states to take on the private sector, and even an unwillingness of the federal government to take on the private sector. I think that's why we still don't have anything like the GDPR in the US or anything like this in most of our states. Interestingly, in Virginia, the legislators who pushed for this law were people of color. It was a black man, a mixed race person, Asian person. They together convinced the legislature to pass this law. They realized the law was weak, but one of the people who promoted it, one of the assemblymen, he said in a public setting that, okay, maybe someday we'll get to AI and facial recognition, but for right now, this is a step in the right direction. And it is a step in the right direction, but it's a teeny, tiny step in the right direction, and not anything that's going to actually materially improve the conditions for people of color in the state anytime soon. Thanks.
Obrigada, professora. Bruno aqui.
Bom dia, professora Anita. Primeiro, muito obrigado pela sua palestra. Acho que todo mundo aqui, principalmente posso falar pela equipe do Data Privacy Brasil, a gente está emocionado de ter você aqui. A gente teve grupos de estudos que a gente analisou as suas obras nos últimos 2 anos. 2 comentários e uma pergunta. O primeiro comentário é nessa evolução normativa que você descreveu no Brasil. Acho que é muito importante também relembrar que o Brasil ele fez uma emenda à Constituição para reconhecer a proteção de dados pessoais como um direito autônomo. E isso muda tudo, talvez seja a principal evolução normativa que a gente teve no Brasil, porque a proteção de dados pessoais passa a ser associado também como um facilitador para várias outras liberdades fundamentais e para vários outros direitos civis. Então, por exemplo, a ideia de você ser tratado como igual, com base no que seus dados pessoais revelam sobre você e de como que você é julgado. Acho que tem uma conexão aí é muito forte. Por que eu estou dizendo isso? Porque, passada a LGPD, a gente ainda está vivendo um momento muito difícil de enforcement dela, né? Como que a gente materializa ela. Inclusive, ela sendo mal utilizada para paralisar políticas públicas afirmativas. Recentemente escrevi um parecer pro bono com um professor aqui da casa, que a gente começava a fazer uma discussão que a resposta para isso não está dentro da LGPD, mas está dentro de uma articulação com outras leis, como, por exemplo, o Estatuto da Igualdade Racial, a própria linguagem constitucional da proteção de dados pessoais como direito autônomo. Então, meu comentário ainda que vocês nos Estados Unidos consigam fazer toda essa evolução normativa, pode ser frustrante quando passado a lei, se a gente não consegue fazer um enforcement e essa adequação com todo o restante do ordenamento jurídico, né, esse diálogo das fontes. O segundo comentário é que essa linguagem mais de direitos civis e de vulnerabilidades, possivelmente a gente tem uma janela de oportunidade, não aqui no Brasil, mas em outros países, relacionados a leis de inteligência artificial, né? Por exemplo, a proposta brasileira ela pode melhorar muito, mas ela tem uma linguagem muito forte de discriminação direta e indireta, inclusive olhando para pessoas ou grupos vulneráveis, de como que eles estão sofrendo mais violência com esses processos de inteligência artificial. E aí a minha pergunta o seu livro, ou um em específico, fala muito sobre o princípio da accountability, né, que é um princípio super quente hoje em várias dessas propostas regulatórias sobre tecnologia, mas ele também é muito criticado porque muitas vezes ele pode ser apenas papel, né? Pensar nessas avaliações de impacto algorítmico, produção de dados, e você faz um argumento que às vezes eu acho que é negligenciado nessas novas propostas, que é a ideia que a accountability é um conceito relacional. Quem tem poder tem que prestar contas e quem vai ser impactado por aquele poder tem que ter o direito de julgar aquela prestação de contas. E aí você faz uma abordagem feminista também sobre esse princípio da accountability. E aí, acho que, enfim, seria quase como se fosse um segundo keynote, mas eu acho que é muito importante a gente ouvir de você um pouco esse pensamento que acho que ele ainda é negligenciado nesse debate que a gente faz sobre accountability.
Thank you very much. I'm glad you mentioned the Brazilian Constitution, because when I said earlier that I'm sort of in awe of your legal regime, it's because you have the constitutional protection of privacy, you have that 2014 civil rights internet law, and you have the LGBT, yeah. You have your comprehensive privacy statute. So you have this triad of what seemed to me to be a very powerful legal framework, and if you combine that with your anti-discrimination laws, then it would seem as though, my God, Brazil is like heaven for privacy, right? But it's not quite. Maybe it's not hell. We're hell. The U.S. is hell for privacy. Maybe Brazil is limbo, or purgatory or something. But we're gonna you're getting there. But on a serious note, I mean, I think that that there's going to be frustration even after you have the ideal law passed. In Europe, after the GDPR was passed, I think it went into effect in the spring. I think it was 2017, 2018. But that same year, I was invited by Giovanni Butarella, who's now passed away, but he was the head of the European Data Protection Commission, and he invited me to come and give a talk, and I said, well, what do you want me to talk about to this group of distinguished data protection people meeting in Brussels? And he said, I want you to talk about ethics, not the law. We have this law now. Now we need to think about ethics, like what do we do now that we have this legal framework in place? And I mention this because it seemed to me that what you're sort of pointing to is that even after you have what seemed like a really great series of laws in place, you're still going to have the question of what we ought to be doing to continue to make things better, and how ought we understand what we have done and what should come next, and what ought we to be doing that the law might not require us to do, but that we ought to be doing. And I think that there's an ethical conversation that needs to happen alongside of and after we enact what we think of as our ideal laws. Because just having the laws on the books doesn't mean that we're going to have instant relief to all the problems that we're experiencing. So that's just respond to the first half of your question. So accountability. So I wrote a book that was published in the early 2000s called Why Privacy Isn't Everything. And it was a sort of a feminist discussion of accountability for personal life. Because it seems to me that as important as privacy is across the board in so many areas of our lives, as important as privacy is, accountability is important too. And accountability for me means being required to give justifications, explanations, descriptions of what we're doing to enable other people to understand what we're up to protect themselves, and to be in a relational relationship with us, to be in a relationship with us, which is based on mutual respect and for each person's value. So in the book, I give examples of how there are contexts in which people don't have an ethical right to privacy because they owe some accountability to other people in their own community or to the nation as a whole. Today, the discussion about accountability has moved into the domain of the extent to which that black box needs to be broken into. We have some window into the black box, some window into what technologists are doing, some window into AI that enable us to hold AI accountable to us. Why? Because we demand the respect that accountability offers us. Why should they owe us explanations, descriptions, justifications? Because they should respect us as autonomous moral agents, as people, as human beings worthy of dignity and respect. So I think that thank you for mentioning the accountability issue. It's very important to me, both because I think we need to hold technology accountable and the companies that make technology accountable, and not just to allow them for profit or other reasons to keep their business secrets and keep their practices that are exploitative of our data just to themselves. We need to break open that black box. But also, I think in the personal realm, think about the ways in which we have accountability in our private lives to our partners, to our families, to our racial groups, to our community. That accountability is very important, and sometimes it means we have to give up privacy in order to show respect for other people who are entitled to our accountability, to our accounting for ourselves to them.
A gente tem tempo para mais uma pergunta só.
Bom dia, professora. Bom dia a todos. Meu nome é O'Hara, eu sou coordenadora da campanha Tire Meu Rosto da Sua Mira, que é o movimento da sociedade civil aqui no Brasil, pelo banimento das tecnologias de reconhecimento facial na segurança pública. É um prazer conhecê-la pessoalmente. E a senhora trouxe um posicionamento a respeito, né, do reconhecimento facial. Um dia, de fato, a tecnologia pode avançar e ser seguro na identificação em relação aos erros para pessoas negras e, especialmente, também para pessoas trans. E aí você também disse que se vale a pena, né? Você fez esse questionamento, que um dia esse argumento não vai ser o suficiente para que a gente possa pedir, então, por uma suspensão do uso dessas tecnologias. E no Brasil a gente está no momento que a gente está votando o PL, a gente está discutindo o PL de inteligência artificial, e no texto proposto inicialmente, o artigo 15 diz quais são as situações em que estaria autorizado o uso do reconhecimento facial. E daí eu queria perguntar à senhora se você entende que a regulamentação das situações em que isso seria viável ou não é um caminho melhor do que o banimento, e qual é a grande dificuldade que a gente tem, se a senhora pudesse discorrer sobre isso, de assumir legalmente, inclusive no texto jurídico, uma posição pelo banimento dessa tecnologia, compreendendo, como a senhora também trouxe agora há pouco, a discussão ética dos resultados que isso implica e que é bem conhecido pelas pessoas, inclusive, que elaboraram o projeto de lei. Então, acho que essa é a minha pergunta. Muito obrigada.
Yeah. Well, there are some cities in the U.S. that have banned the use of facial recognition there are some states in the U.S. that have banned facial recognition technology used by the police or other public authorities, but there's no national ban. I think that that facial recognition technology could be deployed for useful purposes, But I mean, I love it on my iPhone. I love that I can just, go to my iPhone and they can see my face and I can get right into my bank account or my university account. I love that. But I don't love the fact that I might, be accused of shoplifting and put in jail because of a mistaken identity, right? So if we can work toward improving that technology, to making the technology work better, I think it could have some usefulness. Maybe it's okay if I'm recognized in the airport using my face and not my passport. Maybe that's okay. So it's the mistakes that lead to people being humiliated, misidentified by gender, misidentified by race, not identified at all. Those kinds of problems right now are so serious that I think that bans are appropriate. And I would not oppose attempts to ban the technology until it's been proven to be more effective. A general problem that we're facing is that technology has gotten ahead of us, that we've allowed technology to roll out different kinds of facilities that have not been well tested, and now it's like the cat is out of the bag, we say, and it's difficult to put it back in. And that's where we are right now, I think, a little bit with facial recognition. But if we could ban it in those contexts where the consequences of mistake are as serious as being put in jail or arrested, I think that would be a good thing, right? And when it gets to be perfect, or more perfect, when it gets to be non-discriminatory based on race or based on gender or trans identity, then I think we're prepared to use it for these other purposes and feel more comfortable with it. But I applaud you. And I must tell you that every single major civil rights and civil liberties organization in the United States has come out in favor of the idea that that civil rights demand that we put the brakes on the use of AI and facial recognition in particular until it's suitable for equality and social justice. So you have friends. Yes, many friends, yes.
Gente, a gente vai ter que encerrar, mas eu não entendi. Ah, é? Eu vou ter que pedir ajuda aos universitários. Tá, então a gente faz um bloco. Então a gente faz um bloco e a professora finaliza.
Bom dia, meu nome é Arnaldo, eu sou da Bahia, mas atualmente estou fazendo meu mestrado aqui em São Paulo. E eu vou tentar encurtar bastante, porque várias concepções vieram na minha mente. Primeiro, gostei bastante da contextualização, porque aqui, no curso de Direito, eu sou advogado e também internacionalista. A gente visualiza o que é que existe de lei, mas não como essas leis surgiram. E todo contexto legal, já positivado, ele tem uma estrutura prévia, e isso é muito importante de se entender para a gente saber como é que a história se desenvolve. A minha pergunta, e não é necessariamente a pergunta, mas sim um chamado para a gente debater um pouco também, é sobre a questão do código queer em si. Foi passado que existe uma proteção, existe a necessidade de se visualizar a privacidade e de se defender a privacidade. Em contraponto, como a senhora também apresentou, a legislação, em alguns países que tinham um contexto de proteger direitos da comunidade LGBT, tem retroagido. E dessa retroagressão, a gente visualiza algumas perdas. Recentemente, nos Estados Unidos, conteúdos produzidos por influenciadoras, influenciadores e pessoas divergentes que não se identificam necessariamente com o gênero masculino ou feminino têm sido bloqueados para crianças, como conteúdo adulto. Hoje, isso é uma problemática dentro da comunidade LGBT, e a minha pergunta é, qual seria a sua interpretação sobre onde a gente está dentro desse ramo de proteção? A proteção, ela é um direito humano, ou ela já está sedimentada, ela está caminhando para a sedimentação, ou isso está retrogredindo?
Pode falar. Está aberto. So I have a student who's working on his doctorate in law. His name is Iran Globus. He's from Israel. And he wrote a paper for a seminar that I taught called The Queer Opticon, in which he sought to take the basic framework that I developed and to apply it to the experiences of the LGBT community, gays, lesbians, queers, trans people generally. And I want you to follow his name because I think his paper is very important and it may address some of the questions that you're raising about where we are. Are we moving backwards? Are we moving forward? I think that we are in some ways moving backward, in some ways we're moving forward. I mean, the backward is that people are finding it harder and harder to self-identify and have their identifications respected by private and public authorities, and that's a kind of a moving backward. I guess the moving forward is that we do now have, we have a right to gay marriage, we have a right to same-sex sex, we have a right to access facilities, but it's not enough, right? It's not enough because the queer opticon involves not just those kinds of things, but also the ability to name oneself, to self-gender, to refuse to gender, to go online and not identify based on not to reveal one's race, or to reveal one's race. You know, but those kinds of issues of how we negotiate life on and offline as queer people, those are very real issues. And again, I send you to this wonderful young scholar from Israel because I think he's been doing some very important work, and as are others. And on the issue of intimate privacy, I can refer you to Professor Danielle Citron, C-I-T-R-O-N. Danielle has written a book about intimate privacy, advocating for intimate privacy as a civil right. That would include better protection for gay and queer and trans people, and also for women. And she has a new article out in the Yale Law Review Forum about gender and in cyberspace that sort of argues that there's this continuing problem that she and I have both been working on for 25 years about the way in which women are treated online. So there's stuff out there that you can, I think, engage, and you're raising a very important question. I just want to mention one other thing in terms of the history here. Some of you who've studied American privacy law know that the first time a scholar wrote about the right to privacy and advocated for right to privacy was in 1890. Two scholars called Louis Brandeis and Samuel Warren wrote a paper about privacy in the Harvard Law Review, arguing that there be recognized a right to privacy. And their article was the inspiration for the state of Georgia and other states to adopt the right of privacy and in the common law and bring it forward into American law. So that's an important part of history. The historical point that I want to make, and because you mentioned that history can be very useful, is that the brother of Samuel Warren, who was a distinguished lawyer in Boston, was gay. And there's some speculation by Professor Citron and others that one of the reasons why Samuel Warren and Louis Brandeis wrote the article, The Right to Privacy, was because of concerns about the ability of the family to protect their son and their brother from the discrimination which would have fallen on him had it been more widely known and publicized that he was a gay man. I don't know if the story is true or not, but it is true that Samuel Warren had a brother who was gay. But whether or not that impacted the right to privacy in the way that Danielle Citron believes, I don't know. But what a wonderful thought that maybe the problems of the LGBT community affected the growth of privacy law in a way similar to the story I was telling about African Americans helping to advance the right to privacy for all of us. So thank you for your question.
I will allow them to answer 2 questions.
Okay, happy. Yes.
Can answer
Sure,
together,
yeah.
okay?
Okay, thank you.
Então vamos fazer aquele bloco de 2 perguntas direto e aí a professora já finaliza. Pode começar.
Bom dia. Primeiramente, obrigado pela apresentação. Cheia de informações muito interessantes sobre a evolução da legislação nos Estados Unidos com relação à privacidade, discriminação, segregação racial. E aí eu sou Bernardo, sou um advogado aqui no Brasil e estava envolvido também com um movimento social na Europa pelos direitos da privacidade, direitos digitais. E nós tivemos essa discussão lá no contexto de social scoring. E um dos argumentos usados lá foi de que nós não podemos usar a privacidade para contestar. A situação concreta era o social score de uma pessoa que aplicou para crédito e teve o crédito negado porque vivia em um bairro majoritariamente de pessoas negras, cujo histórico de pagamento era baixo. Então, essa pessoa, enfim, ela tinha todas as condições de tomar o crédito e não conseguiu porque vivia em um bairro de pessoas negras. E, à época, na análise lá, as pessoas consideraram que a legislação de proteção de dados não poderia ser usada porque, de fato, o histórico de pagamento das pessoas naquele bairro era inferior a outros bairros. Então, eu fiquei pensando assim, num contexto de países onde a questão racial ainda é muito marcante socialmente, né? Como os movimentos sociais, organizações da sociedade civil, movimento negro, LGBT, de mulheres, poderiam usar a legislação de proteção de dados para questionar ações discriminatórias desse tipo, e especificamente nos Estados Unidos, onde esse ano a Suprema Corte julgou que critérios raciais não poderiam ser utilizados para ações afirmativas no contexto de pessoas ingressando nas universidades. Então, se de um lado a gente tem uma realidade social tão desigual, onde a raça é um fator de desigualdade, por outro lado, a legislação de proteção de dados, que muitas vezes não toca nessas questões, né, cega a essas questões da realidade. Como você, especificamente no contexto dos Estados Unidos, consegue reconciliar isso, e especialmente depois dessa decisão da Suprema Corte?
Eu vou permitir mais uma questão, e aí você pode responder as duas juntas.
Okay.
Vamos lá.
Okay.
Eu ia falar em inglês, mas como eu lutei muito por essa pergunta e a gente não tem muito tempo, vai ser em português mesmo, professora. Eu sou Luísa da Silva, eu preciso falar brevemente quem eu sou. Eu sou estudante de engenharia florestal e eu sou do estado do Pará, sou do norte. E a gente faz parte de uma grande parte da Amazônia. E esse é o nosso contexto, né? Eu sou ativista digital e a gente luta contra o colonialismo de dados na Amazônia. Faço parte do movimento Plataformas. Isso está tudo ligado com a mudança climática, e etc, etc. E a gente tem um contexto em que, nas nossas comunidades, eu sou da cidade em si, mas eu trabalho com comunidades tradicionais, povos indígenas, ribeirinhos, etc. E nas nossas comunidades, a gente está sendo invadido pelas antenas da Starlink. A COIAB, que é uma organização indígena, ela está tendo o apoio do governo brasileiro para receber, nos próximos meses, 8.000 antenas da Starlink, do Elon Musk. Isso é muito problemático, a gente tem tido vários problemas, né, com essa internet, questões de privacidade e dados, entre outras coisas. E, enfim, nesse contexto em que a gente tem povos que vivem na floresta que não têm essa conexão muito forte com a internet, às vezes nenhuma, eu queria perguntar qual o seu conselho para tentar incidir nessa causa, porque é muito complicado, como foi falado antes, com pessoas que não têm quase nada, tentar dialogar sobre tecnologia, por exemplo, quando às vezes só se tem um telefone na casa, ou então se usa a internet via rádio, sabe? Como tentar incidir sobre esse debate num cenário tão dificultoso? Essa é a minha pergunta.
Wow. On the first question, I think that the attack on affirmative action in higher education in the United States was very much an example of politics and the desire on the part of anti-minority groups to find a test case to take to the Supreme Court in order to allow the Supreme Court to overturn a historical practice which was very advantageous for minorities. When I was a little girl growing up, frankly, my prospects as the child of an uneducated mother and father would be that I would become a housemaid, maybe, or if I was really, really lucky, I might be able to teach in a black school or be a nurse in a black hospital. But most likely, I would be, as most of my ancestors were, maids or housekeepers. But then affirmative action was implemented in the United States in the 1970s, which allowed for not just allowed for, but required that schools, universities across the country open their doors to people of all different races. And so I was able to attend a college that I probably wouldn't have been able to attend, and I was able to attend a PhD program in philosophy. I was the first black woman to attend that program. And I was able to go to Harvard Law School, one of the best law schools in the U.S., because affirmative action was on the books. I think I was highly qualified for the things that I achieved, but I do believe affirmative action was an important part of getting universities and colleges to focus on the importance of diversity. It's all about diversity. So this attack on using race as a criteria, it's all just garbage. I mean, it's not as if schools are hatefully deploying race categories to keep out people that they think are inferior, as what happened, say, in the Nazi regime, or happened in the United States before the Civil Rights Law of the 1960s. The kind of affirmative action being practiced that was attacked in the Supreme Court case you mentioned was, to me, a very benign practice that marginally increased the diversity of the universities. We have an issue in the United States about how to deal with our diversity. Do we base our admissions purely on test scores, in which case there'd be probably mostly Asian students in our universities, to be perfectly honest. There's a diversity there. There's a test-taking differential there. And I think the universities are justified in having a population that includes Asians and Africans and Hispanics and Native Americans and all kinds of different people. And affirmative action is a way to do that. And being race conscious is a way to create a more diverse community on your campuses that reflects the diversity of the country, as opposed to having just one race or one nationality or one gender. So I believe that using race to get to, I'm sorry, using race is a legitimate practice in higher education admissions. Do I think that using race is sometimes bad? Absolutely, absolutely. In my book, Unpopular Privacy, I have a whole chapter on the question of whether or not race should be treated as a sensitive category, because as with everything else, there's a politics to that, right? So you can use race as a category to exclude people from jobs as police officers and teachers and university professors, or you can use race as a criteria to divert resources to help communities that are suffering from poverty and exclusion. So the question is how can we decide and choose between the good and bad uses of race data? I don't think that it's inherently evil to use race data. I don't think it's inherently good to use race data. I think it's all very much based on what it's being used for and how it's being used. So I worry in the U.S. far less about using race data than I think some people do. And I think that some of the desire to not use race data is coming from a right-wing place of trying to find a way to exclude minorities from opportunity. There was something, I'm sorry, Victoria, I'm going too long. There was something in California, an initiative early in the 2000s to ban the use of racial criteria in higher education in California and in public life in general. And that movement was not based on people who cared deeply about minorities. It was based on people who were opposed to affirmative action in higher education, wanting to find a legal way to shut it down. And after that law didn't pass, fortunately, but there was a ban on using affirmative action in California that still exists. And as a result of that, there are fewer minority students attending public universities in California at the highest levels. Okay, that's my answer to your question, and I thank you for the question. I apologize for the length of my answer.
That's okay.
So the next question: how can we help deal with people who live in remote communities? Who don't have ready access to technology, who may not even fully understand or appreciate what they're missing and what they're not missing by virtue of being cut off. What do we do about that? How do we address it? It's a problem that's not unique to Brazil by any means, as you know. There are similar problems in India and in the United States as well, technology gaps. I don't have. I wish I had a profound answer for you. I really don't as to what we can do. I do think that that to the extent that people who live in remote areas are expected to contribute by paying taxes and going to the military and so forth, that such folks need to have also the benefits that come from being a part of the larger society, not just the burdens, but also the benefits. And I do think that access to technology for communication purposes and for educational purposes is absolutely vital for everybody on the planet at this time. And so if there are ways to respectfully introduce communications technology, education technology into these communities, I think it'll probably be a very, very good thing. Yet I don't think we should assume that somehow everybody ought to value technology or privacy in exactly the same way. It may be that there are customs and traditions that make people a little bit less concerned about privacy than others, and I think that's okay. But I do think that that access to the internet, which is such an important tool for everybody on the planet right now, is important, and there must be some way found to provide these basic technologies to remote communities. I know in India there's been an effort to provide cell phones to people in remote communities so they can communicate. But then there's been criticism of that because of one of the movements to get cell phones into remote communities in India, it turned out that there was some politician behind it who wanted to garner more votes, and so he was just simply making it possible for people to learn about why they should vote for him, right? So we have to understand why we want technology to be more broadly distributed, how it's going to be used, and to find ways to make that possible that don't involve people, say, giving up vast quantities of data without anything in return, or people being abused and manipulated by the technology. So I congratulate you for your work, and I wish I had some simple, profound answers, but my bias is towards getting the technology for educational and communication purposes to everybody who needs it on the planet, but then to understand that there will be cultural differences in how technology is used, and there must be protections in place for everybody whose data is used for whatever purposes to prevent them from being dehumanized and exploited. So that's my answer. Thank you. Yeah, thank you.
Thank you, professor. Obrigada, professora. Gente, a gente precisa terminar. Queria agradecer mais uma vez a professora Anita Allen por ter disponibilizado o tempo dela para estar aqui com a gente. Agradecer a todos vocês que também disponibilizaram seu tempo para assistir essa maravilhosa palestra, ouvir a professora falar. E agradecer também ao Data Privacy por nos proporcionar esse momento. Muito obrigada.